Hello friends, myself Mohit and I am going to dictate you Steno legal matter. Please subscribe my channel and press the bell icon for more dictations. So be ready for the dictation. 5, 4, 3, 2, 1, start.
Learned counsel for the appellant submits that this fact is not disputed, that the date of birth of the appellant, which is recorded in the school records, is when the criminal case was instituted against him. He was 12 years of age. Stop. No such charges at all could have been levelled against the juvenile of an allegation that he had fraudulently prepared of a forged caste certificate, and in mechanical process the charge sheet came to be filed, but the learned trial judge on examination of the record discharged the appellant by an order after recording a categorical finding that there was no evidence available on record on the basis of which the charge could be prima facie proved against the appellant for either of the offences levelled against him, and after a decade the process of selection was initiated by the respondents pursuant to an advertisement wherein he was acquired to indicate by filing an attestation form under clause 12 as to whether he was ever been prosecuted or arrested or detained. Stop. In the instant facts and circumstances, when there was an order of discharge passed by the court of competent jurisdiction, neither he was said to be prosecuted nor he was arrested, and thus the information which was tendered by him in reference to clause 12 of the attestation form filed by him was not a case of misrepresentation or of concealment which led to the cancellation of his appointment by the authorities by an order. Stop. Learned counsel further submits that the division bench has failed to look into the material aspect of the matter, and the finding which has been recorded of suppression or concealment by the appellant, which he had intentionally not disclosed in the attestation form, is not supported by the material on record and unsustainable in law. In support of submissions, learned counsel has placed reliance on the judgment of this court in Avatar Singh versus Union of India and others. Stop. Per contra, learned counsel for the respondents, while supporting the finding recorded by the division bench, submits that there is material concealment made by the appellant by not disclosing the correct facts in his attestation form, and particularly in clause 12 where he was specifically asked to indicate as to whether he has ever been arrested or prosecuted, and once this fact stands established from the record that a criminal case was instituted against him which he had failed to disclose, and that being the basis for passing the order of cancellation of his order of appointment by an order, no error was committed by the division bench of the High Court in the impugned judgment, which calls for interference of this court. Stop. We have heard learned counsel for the parties and with their assistance perused the material available on record. Stop. It is not disputed that the date of birth of the appellant in the school and he was a juvenile of 12 years when a criminal complaint was instituted against him on the court stop.